should know that you have the right to disagree with your school system over the appropriateness of your child's special education program. By the way, they can also disagree with you. The fact is, you can get into a dispute with your school district, and there are several ways of going about it, but we're going to talk right now about mediation as a way to resolve a dispute.
Right. So the IDEA, which is the Federal Special Education Law, the Individuals with Disabilities Education Act, provides that all states must make available to families and school districts a mediation process. And what that looks like is it is a voluntary process. That's important for families to know because you could want to mediate your case and your school district could say no.
And then all bets are off.
Then, then they would be within their rights to say no. Both sides have to be willing to participate in the process. But mediation must be made available to parents and school districts. And this is also important. It cannot be used to delay a parent's right to exercise their rights through a due process hearing. So if a parent doesn't want to mediate, or they want to mediate, but they also want to file for a due process hearing, which is a different forum under the IDEA. The school district and the state can't say, well, first you have to mediate, and then we'll let you file for a hearing. You have a right to file for the hearing, even if you also want to mediate. It's also important for parents to understand that mediation is a forum available to families even prior to filing. So if you choose not to file, you don't have to have done that. You don't have to file for a due process hearing to have the right to go to a mediation. But again, the school district could say, we don't want to mediate with you, and it has to be voluntary on both parts. Another thing to remember is that mediation is supposed to occur with an impartial mediator. So it should not be someone who's employed by the school district that you're disputing with. This is one of those practical versus legal issues now I want to get into. Every state is different, even though the federal law governs all 50 states. Every state does things a little bit differently. And I would my suggestion to parents who are considering mediation would be to talk to other parents and even parents, attorneys, and other advocates in your state, special education advocates, about whether they've had any success with the mediation process in your state. When I talk to attorneys in some states, they'll say that they never mediate, that they feel that the people that the state assigns as mediators are not, in fact, impartial, even if they are by law impartial, and that they don't use the process at all. And in other states, they use it all of the time and use it successfully. And even within a state, you may say, I'll mediate, but there's only a particular mediator that I feel is fair. So ask around before you go to the trouble and risk of going forward in a mediation. And the reason I say it's a risk is, you have it's time out of your schedule and out of your life that you're setting aside, and perhaps you are choosing to delay filing for a hearing in order to mediate. But you're going in there in most cases as a parent unless you have counsel and unless you have an advocate with you or, someone who's experienced in this area. Usually not having gone through this process before, and in all likelihood your school district has. So you're already at a disadvantage. And you could disclose information in that mediation that you might not be in a position to have to disclose, and it might not be advisable for you to do so. You might be asked to sign things at that mediation that you're not in a position to understand. So before you jump into mediation, while it's a fantastic opportunity to resolve a dispute, it's not necessarily the best option depending on your case and where you are.
And what I'd like to say about any dispute. With any dispute, you're looking at an output of money, time, emotional, the emotional toll that it takes on you. And I think, I don't know if this is transferable into every state, but let's talk about whether or not you must have an attorney at a mediation, or if you could represent yourself at a mediation, or you could have an advocate.
Right. Well, I would think it would be a violation of the federal law for a state to require a parent to have an attorney at mediation, because you have the right to mediation and there's no allocation of, counsels if you're a criminal defendant. So you would be forcing parents to hire attorneys, even though in many states you have access to legal services that may be free or at low cost. That does not necessarily mean that they're experienced special education counsel. So for parents, I don't think you could make such a requirement. Now, the next question is it advisable to proceed in a mediation without an attorney? I obviously don't think that it's a smart idea to do that, because I am a parent's attorney and I've seen many parents sign documents at mediation that I wish they hadn't, that waive rights that they didn't realize they were waiving or didn't understand that they were waiving. Whereas the special ed director, even if they don't have their lawyer there, they may have their lawyer at the other end of a phone call. They might have gone through this 100 times that school year, and they know exactly what the language means. And you're in an innate disadvantage when you walk into that process. So I think if you're going to be in a mediation where you're going to be considering waiving your legal rights, having counsel with you is very wise. Now, I realize that's not
Well, not all
something
parents
many
can.
parents can do.
Not
Right.
all parents can afford to hire an attorney,
Right.
and so the reason I mention that is I think it's important for parents to understand that that is an option. If you know of a reputable advocate who could represent you at a mediation, and it is most often a more affordable way if you can't afford an attorney.
Right, and that gets tricky too. I mean, there are
know.
some states where there's a lot of pressure on advocates not to represent parents at certain meetings because they'll be accused of the unlawful practice of law without a license, and often that's pushed back against very effective advocates by school districts, but that's a separate issue. What I would just say is most of the attorneys in most states who represent parents are very happy to speak to parents, even if they're not hired. Spend a half an hour on the phone with a parent who's going into a process like a mediation and say, okay, what are your issues, what are your concerns, or at least tell them whether or not it's a good idea to proceed.
You certainly don't want, if you're representing yourself and you're not with an attorney, you want to be prepared as best you can.
Absolutely, but everything that's important to keep in mind is this. I highly encourage any opportunity you have to resolve your dispute amicably with your school district. And if mediation gets you there, then that's great.